Oh, Maria Watts is calling me. G'day, Maria. Yes, I'm sitting right here with my video on. Thank you. Bye.
Yeah, my name.
Yeah, and it's got volume, right?
Turned up.
Good.
Turned it down.
It's Maria again. Hi, Maria. Oh, g'day. Good. Fuss about her.
Council stand. The coroner's court of now in session. Please be seated. Continuing with submissions, I think we're hearing from Ms McNally, is that correct?
Yes, thank you, Coroner.
It's a different name coming up on your screen, so it just left me a little bit perplexed. But thank you, Ms McNally. Thanks for making yourself available over the link.
Thank you for making that available, Coroner. McNally for Sgt Bowens. We refer and adopt our submissions of the 11th of November 2024. The coroner's powers under the Act are dealt with at paragraph 13 to 32 of our submissions. We explain in those why the way forward urged upon you by your counsel is wrong and would lead you into jurisdictional error. In relation to the submissions filed by the families, it is clear that they want the truth, that they want to avoid another death, and despite past experiences, they have placed their faith and their hope in this coronial process. If we are right on scope, then the effect on families who have put their faith in this process will be great. And that is the real world consequences if a court does go beyond scope. The scope issue was dealt with. The scope and what we say were improperly obtained text messages was dealt with extensively by Mr. Officer yesterday. I adopt those oral submissions. For the purpose of my submissions today, a focus will be on the issue of resourcing, both of the court and the interested parties. This in turn impacts the fulsomeness of the evidence before the court and the quality, that is, its ability to be relied upon and to make findings, recommendations and comment, and also issues of natural justice and procedural fairness. As discussed in the Kumanjayi case, resources are finite and the public interest often will be better served by the expeditious and economical dispatch of business than by the undiscriminating pursuit of evidence which the tribunal regards as having no reasonable likelihood of influencing the outcome of the hearing. If our submissions are correct, we would say it's worse than that, and it has gone beyond the actual ambit of the Act. It is likewise important for the parties who may be subject to adverse findings and comment or recommendations to be in a position to fully participate in the coronial process, to test propositions and to test evidence. Fully participate in this coronial process would mean being in a position to consider the vast evidence this coronial has considered or had available to it, including a large brief of evidence, nearly 70 days of hearings held in tranches, over 5,000 pages of transcripts, and many written submissions, with some exceeding 400 pages. Lawyers are not cheap. Many people at the bar table will have incurred expenses of hundreds of thousands or millions of dollars, including flights from Melbourne and Sydney. This is the level of funding that each participant in this coronial should have had if there was ever to be an ability for interested parties to fully participate in this coronial process. The consequences of this not happening is that there is evidence, we say, and I will enlarge on this later, that is incomplete and often not tested. And this really goes to the truth that the parties and the families are seeking. Further, the lack of ability to fully participate has on occasion been used as a basis not to allow evidence or comment in from particular parties. It's been put to my client, well, you were represented at this coronial. We say our client was not represented at the entire coronial. Our client was represented at approximately 7% of the coronial. Your council's written submissions are not in an orthodox form. I did my best in my written submissions to unpick the allegations against my client and the evidence said to support it. And I have summarised these into what I call the 4 issues. Issue 2 and 3 are in relation to allegations that my client condoned or encouraged certain behaviour. Your counsel has attempted to knit this allegation together by Ms. Campagnaro's evidence, which was that she was told by Mr. Rolfe that our client had fixed up jobs for Mr. Rolfe, and she was aware that our client freely used racist language. At transcript 2762 to 2763, Ms. Campagnaro says that she was told by Mr. Rolfe that Lee Bowens and another officer had on several occasions dealt with his reports and unjustified use of forces for him. She was then asked for her impression of what that meant. Now, I pause to note the difference in treatment where a witness is being asked for her impression of what words meant, but other witnesses were stopped from providing comment, for example, on the 5 a.m. plan. Counsel assisting did give my client an opportunity to comment on Ms. Campagnaro's evidence, which he read out to him. Now, counsel assisting had to read it out to him as my client did not have the resources to have his legal team attend when the original evidence was given. Despite that, my client's evidence was very clear. He said, and this is at transcript 4964, Zach was never on my patrol group, so I never had an opportunity to do use of force or saw him on patrol group. I don't believe I did any use of force for IRT deployments because our use of forces were basically non-existent. So unless my name is on a use of force that you can present to me and I can comment on, I'd say it's completely untrue. Now, as far as I'm aware, the coroner's or counsel assisting did not then take the natural next step and call for these alleged use of force documents. Ms. Campagnaro also says that she heard our client freely use racist terms. The question was put to Ms. Campagnaro by counsel assisting, is he a sergeant who, in your memory, in your mind and in your memory, was freely using these kinds of racist terms? And the answer was, yes, he was. Freely means in generous or copious amounts. As far as I'm aware, did counsel ask her particulars of these alleged instances? No. Do we know when, where, how often these allegedly happened? No. Once a day, once a week, once a fortnight? Don't know. It was indeed fortunate that with our limited resources, we were able to attend some hearing days in October 2022 and obtain evidence from 7 witnesses on oath that they have never heard our client use such language and were surprised in relation to the text messages. And these were Constable Ebel, Constable First Class Anthony Hawkins, Constable James Kirstenfeld, Officer Donaldson, Sergeant McCormack, who went on and said that Sergeant Bowens is probably the best sergeant he's ever had, Sergeant Evan Kelly, and Superintendent Nobbs. And it was indeed fortunate that we put these questions to the witnesses because based on opening submissions, they gave no hint that particular officers would be subject to potential adverse findings, comments or recommendation. We're not sure what has changed since opening submissions were made. The weight of the evidence before the inquest is that Sergeant Bowens is a dedicated and experienced officer and leader. In October 2014, Sergeant Bowens left the TRG to move to frontline duties in Alice Springs. He attempted to make efforts to improve quality of police services in Alice Springs, including by forming the IRT and making efforts to increase training and resources for these police officers. So we now have a situation where we have evidence from Ms. Campagnaro regarding use of force, where there's no details, and that she heard my client freely make racist comments. So what is the court supposed to make of this? Your coroner is in a difficult position given the evidence before you. Your counsel's submissions go into detail about where Ms. Campagnaro's evidence can be accepted as truthful. And then there's another bucket, and that's where they don't want you to make any findings. And why? Well, it's explained because of the complexity of the issue. Now, I'm not sure what that actually means. We say that it is not appropriate for you to cherry pick what parts of a witness evidence to accept and then not make any findings on the rest of it. It is trite to observe that if a witness gives false evidence, that is relevant to the weighing up and balancing of the truthfulness of the rest. We submit that you must make a finding on all of Ms. Campagnaro's evidence, and we say that on the evidence before you, that must include a finding that the evidence in relation to my client was not true. It is an unusual situation where findings of truthfulness must be made at a coronial, but that is the consequence that flows from the position taken on scope. Counsel assisting says the decision to disband the IRT was a wise one. Now, that is because, allegedly, because the IRT no longer exists, you are entitled to assume that there was never a need for it. This is a naive observation which disregards the evidence before you. The evidence was given by my client, including in his statements, that there is a need for it, a properly resourced IRT-style group. The fact it was not explored is a significant blind spot in this coronial and will impact the family's ability to come to the truth. There was no evidence except from my client, as far as I'm aware. The finding urged upon you by counsel is contrary to the evidence, as well as contrary to common sense for reasons which I'll explore. The evidence before the court is that years before the death, my client begged for training and for resources. What was not explored was why was this training and resources not forthcoming? Evidence of these requests are in my client's 2020 statement, which is in the brief at 707, and I have set out the memos at paragraph 65 of my submissions. These were memos prepared years before Mr. Walker's death. As far as I'm aware, it's not been explored in any meaningful way why the requests were not acted upon and ignored. If the scope of this coronial is as broad as counsel assisting says it is, surely this would have been a fundamental plank of the investigation. In relation to the IRT generally, we are not aware that this court has sought comment from any remote communities in relation to their experience with the IRT, which from the evidence before you is that it was very positive. The court has not explored why less lethal beanbag guns introduced by my client were removed. The absence of these inquiries is inexplicable to us. My client gave real-life examples in his statements, which are from 2020, and the examples are given in relation to periods before the IRT was disbanded and after the IRT was disbanded. As far as I'm aware, no questions were asked about these real-life examples. For example, in one of the statements, in 2016, Pandey Valesky killed a French national in an unprovoked attack with no warning. The IRT were called out at 10:30 p.m. and deployed to Tea Tree. Valesky was found naked and distressed and given medical treatment. The specialist section from Darwin arrived 14 hours later. By that time, it is open, and it is my client's view, that Mr. Valesky may have died from heat stroke and other people may have been injured or killed during that 14-hour period. There are the April and May 2016 riots at Ali Kurong. Now, compare these examples to a 2022 example, which is also given in my client's statement. In 2022, there was a victim of a domestic violent attack. The victim lived in Tea Tree, some 190 kilometres north of Alice Springs, whose car was shot at. Now, whose safety was secured 14 hours later after a 000 call. For someone living in a remote community outside Alice Springs who is in imminent danger, what do they do now? The IRT does not exist, and it will take 14 hours for the TRG to arrive. These issues have simply not been explored. The only evidence before the court is my client's evidence that the disbanding of the IRT will result in deaths. If we are wrong on scope, and if you are able to make recommendations that have been urged upon you, we seek a recommendation that the Northern Territory Police Force undertake a review in relation to the need, structure and cost of a properly resourced tactical response group based in Alice Springs that is created in conjunction with Aboriginal groups. And that funding and resource is what my client has been seeking for many, many years. In relation to the plan, various people have given, and some have tried to give, evidence or comment in relation to the 5 a.m. plan. Now, rather than take the usual approach and allow this evidence in and then decide its weight at the end, in some instances, the court has not allowed certain evidence or comment in. There are two examples. Carrie Joy provided a statutory declaration on the 20th of May 2024, and certain paragraphs 105 to 121 were not allowed in, and the explanation was this. It is primarily Mr. Joy's opinions which are given when he does not have privy to all or even most of the evidence received at this inquest, in particular concerning the events of the night of November. Mr. Joy was not a serving member of the police force and has not been for some years, nor was he present. By contrast, I have ample evidence from persons present and from others who have direct knowledge of the events, all of whom have provided timely statements, who were available for examination in a way that provided procedural fairness to all. It may be that you would have, in the end, given this evidence very little weight for the reasons which I've just read out, but to not accept the evidence or the opinion of someone who's come to the court to try and give it, who has experience in the area, we say will result in perhaps important information being missed. On the 27th of May this year, our client attempted to give further evidence in relation to the 5 a.m. plan, and that's at transcript 5648. This was refused, and it was said, "You are being represented in these proceedings, Mr. Sergeant, and we have received evidence widely from many, many different people, and I will not be receiving any evidence further on this point from the witness box in the circumstances where I have had direct evidence from all, from many different people within the police force, directly those on the ground, and also other higher-ranking people who have provided opinion on this." Sergeant Bowens is an experienced police officer with TRG training and who created the IRT, and he was not allowed to provide further comment. Why? Number one, he has lawyers. Our client has not been represented at this coronial. He has been represented at 7% of this coronial. Number two, it is said he does not have all the information that the coroner's court has. It is true that Sergeant Bowens was unable to fulsomely participate in this coronial. At its heart, our client's impecuniosity has resulted in some of what we say, the most relevant informational comment not being before the court. And evidence, and we say evidence, which counsel wants you to rely on, is incomplete and untested. That is why the scope of coronials are not as broad as your counsel urges. There may have been, and there probably are, vehicles by which these issues could be explored, but the Coroner's Court and the Act does not, we say, give you that power, and it is not fit for purpose. And the result is that the findings, if they are made, will be based on incomplete evidence and will be beyond power. And they are my submissions. Thank you, Coroner.
Thank you very much, Ms McNally. Are you staying on the link, or are you following us on the live stream, or?
If we can stay on the link, but I will turn my camera off and microphone off.
Thank you.
Thank you.
Yes, let me have a look at our list. Wait a minute.
Mr. McCarthy.
Good morning, Your Honour.
Good morning, Mr McCarthy.
My name's Michael McCarthy, and I'm responsible for making submissions on behalf of the teams that made up the former Department of Territory Families, Housing and Communities. I do so having consulted with the relevant teams that now sit within a number of other departments, including the Department of Housing, Local Government and Community Development, the Department of Children and Families, the Department of People, Sport and Culture, and the Department of Corrections. At the outset, I'd like to express my condolences to the family and friends of Kumanjayi Walker on behalf of all of the staff of the former department. I've spoken to staff who had involvement with Kumanjayi Walker, and all are saddened talking of his loss. It is clear that based on my discussions with them and my engagement with this matter, that Kumanjayi Walker was a strong young man who had a spark about him and who had an incredible connection with his family and with Yundamur. The loss of Kumanjayi is significant. On behalf of the staff of the former department, I also want to acknowledge that there is more work to be done across all aspects of service delivery, particularly in remote communities, including in remote housing, child protection and family support, domestic and family violence, and youth justice. The coroner has heard extensive evidence in this inquest about the reforms the department is undertaking to improve its services and, more importantly, to improve the lives of the people that it serves. That work continues today, and the department welcomes the lessons from this inquest as part of that work. The former department had a unique understanding of Kumanjayi, given the number of its staff that had engaged with him. In reviewing Kumanjayi's case, there are examples of good practice and there are aspects of service delivery that have been identified as requiring improvement. We submit that the findings of the coroner should recognise both. With respect to child protection, Kumanjayi first came to the attention of the department in his early infancy, in circumstances where Kumanjayi's mother and father were unable to care for him. The department facilitated family meetings to work with the family to identify an alternative carer. Miss Leanne Oldfield volunteered to care for Kumanjayi. This led to a good outcome for Kumanjayi. It kept him with family and it kept him in Yuendamu, both of which were extremely important to him. Some of the submissions suggest that Kumanjayi was brought into care. This is not correct. Kumanjayi remained in the care of his family throughout his life. The records of the department suggest that Miss Oldfield cared for Kumanjayi very much and raised him in difficult circumstances. It is also clear that other family members provided assistance in caring for Kumanjayi at various times, including Katrina and Margaret Brown, the Robertson family, and many others. The department accepts that more should have been done to support Miss Oldfield and to develop a safety network of family members to assist with Kumanjayi's care. In this regard, I refer Your Honour to the Signs of Safety Practice Framework that was implemented by Territory Families in 2018. This is discussed from paragraph 312 of the affidavit of Gabrielle Brown. The Signs of Safety Practice Framework is designed to facilitate engagement with a network of persons who are naturally connected to the young person. Under the framework, practitioners develop a plan that draws on and places responsibility for a young person on a larger group of persons. Such an approach would have pulled in a greater number of persons in the community to take responsibility for Kumanjayi. This type of safety planning is most effective when Aboriginal staff with an understanding of the community are involved in the process. Since 2007, the department has employed Aboriginal family support workers in Yuendamu. The benefits of having Aboriginal remote family support workers employed within communities cannot be overstated. Remote family support workers bring with them local knowledge of the community, its culture, and the families that live within it. They would typically be able to speak one or more of the local languages, and they have the capacity to build and maintain relationships within the community. Remote family support workers working alongside child protection practitioners promote culturally informed practice and actively include family and cultural considerations. The evidence before Your Honour establishes that Aboriginal remote family support workers in Yuendamu developed a good relationship with Kumanjayi and were involved in service delivery to him, particularly in locating and communicating with Kumanjayi's family and involving them in decision-making with respect to Kumanjayi. Child protection and family support staff remained involved with Kumanjayi throughout his life, engaging Kumanjayi with therapeutic supports, engaging with family, ensuring Kumanjayi was receiving medical care, safety planning, taking steps to engage Kumanjayi in schooling and providing financial and other practical supports. The details of the department's engagement with Kumanjayi are set out in the affidavit of Gabrielle Brown from paragraph 67. With respect to youth justice, again, there are examples of good practice and examples of where the department fell short. In Kumanjayi's early teenage years, he began engaging in antisocial behaviour and low-level offending. In 2014, when Kumanjayi was 13 years of age, he had his first serious involvement with the youth justice system and he was sentenced to a short period in custody at the Alice Springs Youth Detention Centre. He would go on to spend further periods in Alice Springs, in the Alice Springs Youth Detention Centre and in Dondale. It is clear that Kumanjayi continued to have a close connection with Miss Oldfield throughout this period. That much is evident, noting the significant number of phone calls he had with Miss Oldfield during his periods in custody, often multiple times per day. The evidence establishes that while Kumanjayi was in youth detention, he was engaged in schooling, received medical care and support from mental health professionals, and that psychologists were involved in delivering counselling to Kumanjayi and in implementing behaviour management strategies. The records make it clear that a significant number of service providers, supported Kumanjayi and worked together in an attempt to put him on a different path. His first period in detention is illustrative. During Kumanjayi's first period in detention, Aboriginal remote family support workers, child protection practitioners, staff from corrections, the Department of Education and WIDAC all worked with Kumanjayi's family to develop a plan for him. Under that plan, Kumanjayi was bailed to attend Bushmop, an Aboriginal-controlled residential rehabilitation program. Kumanjayi would then spend a period at Mount Theo, an Aboriginal-controlled youth diversion program, and Kumanjayi was enrolled to attend an Aboriginal-controlled boarding school known as SevGen. This is an example of good work undertaken by the department and the other service providers that were working with Kumanjayi. It was arranged in consultation with Kumanjayi's family. It involved a number of Aboriginal-controlled programs, and it had the potential to put Kumanjayi on a different path. On the other hand, it is also accepted by the department that there were periods of detention during which limited support services were delivered to Kumanjayi, and that more should have been done to assist him. The department has done a lot of work to improve service delivery in youth justice space, and it is committed to continuing on this journey. Details with respect to relevant reforms in youth justice are set out from paragraph 265 of the affidavit of Gabrielle Brown. Speaking briefly to housing, I would like to be clear that there are submissions made by Councillor Sistin and the other parties that the department does not accept. The department does not accept that there is no evidence that houses in communities are designed to meet the practical needs of families. The department does not accept that there is no evidence before Your Honour that houses are designed to meet the cultural needs of family. And the department does not accept that the issues raised with public housing in remote communities are examples of institutional racism. None of this is to shy away from the fact that more work needs to be done. The department is committed to continuing to improve public housing in remote communities. Since taking responsibility for remote housing in 2012 from the Commonwealth, the Northern Territory has invested significant funding into remote housing, and its staff have worked extremely hard to improve the stock that was handed over to it and to build new houses of a high quality in remote communities. To provide some idea of the scale of the investment, in 2020, $2 billion was committed to funding public housing in remote communities under the 10-year program Our Community, Our Future and Our Homes. Of this $2 billion, the Northern Territory Government contributed $1.5 billion. In March 2024, a new federation funding agreement was signed between the Commonwealth and the Northern Territory Government, committing $4 billion over 10 years. Of this $4 billion, the Northern Territory Government committed $2 billion. These are significant amounts of money in the context of the Northern Territory. On a per capita basis, the Northern Territory Government spends considerably more on public housing than the larger states like New South Wales and Victoria. The evidence before Your Honour confirms that the investment and the efforts of the staff of the department are making a difference. They are making a difference with respect to the number of homes that people can live in. As at June 2024, a total of $782.7 million had been spent under the Our Community, Our Future and Our Homes program, building 640 new homes across the Northern Territory. They are also making a difference with respect to the livability of the housing stock in remote communities. The evidence before the coroner shows that in Central Australia, new build housing is of a high quality. They contain reverse cycle air conditioners, covered balconies, eaves, and are insulated. They have an average energy efficiency rating of 6.4 stars. This is close to Dr. Quilty's expectations. Further, the evidence before Your Honour confirms that the views of the community are being taken into account. In this regard, I refer to the evidence of Brent Warren with respect to the operation of housing reference groups, local decision-making, and in the engaging of Aboriginal-controlled housing providers. The people that I work with at the Department of Housing are proud of the work they are doing in communities and what is being achieved. With respect to recommendations, I understand that Councillor Sisting will be circulating recommendations shortly. I want to take the opportunity to emphasise that the department are looking forward to seeing those recommendations and to working with the other agencies and non-government service providers, particularly those that are Aboriginal controlled, and with the community to improve the lives of persons in communities.
Thank you, Mr McCarthy. Mr Hutton?
All right, before Mr Hutton commences, may I, unfortunately, I
Bowens,
must withdraw in a few moments. Ms Moreau, KC, will continue to represent the Brown family. Thank you.
Thank you very much.
KC.
Yes,
Your Honour,
Mr. Hutton.
NT Health has filed detailed written submissions which, among other things, respond to the primary submissions filed by Councillor Sisting and some of the other parties. I will not recite those submissions at length this morning, Your Honour. I propose to emphasise a few matters of importance to NT Health. For the avoidance of any doubt, NT Health relies on its written submissions in full. The first matter I wish to emphasise, Your Honour, which is set out at paragraph 3 of those written submissions and elsewhere, is that NT Health acknowledges the deep and ongoing trauma and the grief experienced as a result of Kumanjayi's tragic death. It is a profoundly saddening event. NT Health extends again its sincere condolences to the Brown family, to the Walker Lane and Robertson families, to Kumanjayi's friends and to all those who cared for Kumanjayi. NT Health also respectfully acknowledges the contribution of the Brown family, the Walker Lane and Robertson families and the Parumperu Committee to this inquest, including their extensive closing submissions. Further, Your Honour, NT Health acknowledges the lengths to which those parties, Councillor Sisting and the Court more broadly, have gone to make this inquest accessible to the Yuendamu community and to the broader public. As Dr David Reeves stated in his evidence, Your Honour, it is devastating that nursing staff from the Yuendamu clinic were not with Kumanjayi on 9 November to render him any assistance or comfort that they could. Many of those staff have devoted decades of their lives to serving their community and improving health outcomes, particularly for Aboriginal people in remote communities. Many of the staff involved had lived in Yuendamu with their own children or other family for years and felt the loss of a young person from their community sharply. The reason those staff were not in community is, in our respectful submission, simple, Your Honour, and that is safety. Dr Reeve, the then General Manager of Primary Healthcare in Central Australia, determined it was not safe for those staff to remain in the community over the course of the weekend and they were to be temporarily withdrawn. The reason there were serious concerns for safety was that from between 6 to 9 November 2019, the nurses in Yuendamu had suffered 3 attempted home invasions, 1 successful break-in, 1 attempted break-in, and 3 break-ins to vehicles. Councillor Sisting submitted yesterday that the break-ins at nurses' accommodation must have been distressing, upsetting and frightening to those staff, and we embrace that submission. The very real danger that such threatening behaviour poses to safety should not be controversial. It's well acknowledged in the literature, it's been acknowledged in other coronial inquests, and it's been acknowledged by Councillor Sisting and many witnesses during the course of this inquest, both Walpuri and non. Elder Warren Williams' evidence to this inquest was that the nurses were evacuated for a good reason, and I don't blame them for that. It's acknowledged, Your Honour. You also acknowledged it, Your Honour, at the conclusion of Dr Reeves' evidence. NT Health maintains the decision to temporarily withdraw its nursing staff from Yuendamu on 9 November was appropriate and justified in the circumstances. The temporary withdrawal guideline, in force at the time, provided the process to be followed in the event that a temporary withdrawal was contemplated. The considerations identified in the guideline included: are staff safe in the community? Are staff at risk of harm? Have the police been notified? and logistical support, including appropriate transport and accommodation for staff. Dr. Reeves' evidence was that whether staff are safe in a community itself required consideration of a number of other factors, including the staff members' subjective perception of their safety, the objective circumstances giving rise to the concern that staff may not be safe, and the infrastructure or services available in the community to keep staff safe. In applying the temporary withdrawal guideline and considering a potential withdrawal of staff from a community, Dr. Reeve also had regard to the likely health requirements of the community over the temporary withdrawal period and the availability of health services outside the community, particularly the proximity of the nearest health centre. Once a decision to withdraw staff had been made, the temporary withdrawal guideline directed that a number of notifications should be made, including how to notify the community. In his evidence, Dr. Reeve identified that in the years preceding the events in Yuendamu, safety concerns had required the temporary withdrawal of the health service from other locations in Central Australia, from Ali Karung, from Imampa on 2 separate occasions, and from Alaura. In Yuendamu, Dr. Reeve considered that staff should be withdrawn for several reasons. Firstly, the staff did not consider themselves to be safe. According to Dr. Reeve, staff's own perceptions of safety is important because they are the ones present within the community and observing community attitudes firsthand. If staff do not themselves feel safe, that is a warning that must be carefully considered. In Dr. Reeve's experience, and contrary to the submissions that are made by others, staff tend to underestimate threats to their own safety rather than the opposite. The number of break-ins and attempted home invasions and attempted break-ins, as well as the vandalism of staff cars, were considerable, particularly in such a short period. Staff felt that they were being targeted, and given the break-ins and attempted break-ins had occurred at accommodation in different parts of the community, Dr. Reeve understood why staff felt that way. Dr. Reeve considered that the antisocial behaviour towards the clinic staff was escalating. Home invasions, Your Honour, when staff are present in their accommodation, pose a particularly high risk to staff. Dr. Reeve's evidence was that in his experience, break-ins typically occur when remote staff are not present. For example, at teachers' accommodations during school holidays. Invasions that occur when staff are home and known to be home pose a different kind of threat. It shows a certain brazenness by those involved, according to Dr. Reeve, and it is more likely to result in violence. There is a risk of the victim being assaulted if they try to stop the intruders from getting in or taking their belongings. There had been unlawful entries in Yuendamu earlier that year, which had been distressing to staff. In particular, a staff member had been broken into while she was at home and had woken up with an intruder standing over her in her bedroom. That incident and the abduction of remote area nurse Gail Woodford from her home in South Australia 3 years earlier weighed on Dr. Reeve as he considered the potential withdrawal of staff. Dr. Reeve also considered that the after-hours call-out service could be performed from the neighbouring community in Yuendamu over the weekend. Dr. Reeve was aware that a call-out service had been provided, albeit in the opposite direction, over the Christmas period in 2017 and 2018 without issue. It was also being provided at the time that Dr. Reeve deposed his affidavit for this inquest. Making this assessment, that is, determining how best to deliver health services while also maintaining the safety of its staff, is the core business of NT Health. That was the evidence of Naomi Heinrich, the then Regional Executive Director of Central Australia, as well as Dr. Reeve. Ms Heinrich stated, that's a balance of risk that we have to undertake every day. This decision to temporarily withdraw was considered carefully, soberly, and fully cognisant of the importance of health services being available in a remote community. Dr. Reeve brought to his decision-making many years of living in and working in remote communities in the Northern Territory and in Western Australia. Those supporting Dr. Reeve in this decision-making process, including Helen Gill, were similarly experienced. Miss Gill has lived in several remote communities since moving to Central Australia as a remote area nurse in 2004. Now a clinical nurse manager in Alice Springs, Miss Gill regularly spends the summer holiday providing nursing cover at remote clinics. This is not done with any misunderstanding of the importance of remote health services to those communities. Dr. Reeve also holds a doctorate in public health. These practitioners are experts in their field, just as Dr. Boffa and Dr. Archie are, as counsel assisting submitted yesterday. And caution should be exercised before their assessment is disregarded or their motivations are impugned. Notwithstanding that the decision to temporarily withdraw nursing staff from Yuendamu was justified in our respectful submission, Your Honour, Dr. Reeve and Miss Gill each accepted that this withdrawal had revealed a need to review and strengthen the decision-making process. For example, as Dr. Reeve noted in his evidence, the temporary withdrawal guideline in force in 2019 did not place an appropriate emphasis on consultation with community members, including elders and other stakeholders. This has since been remedied. Amendments to the temporary withdrawal guideline occurred proactively well prior to the commencement of this inquest. As is detailed in our written submissions, Your Honour, there have been a number of further changes and improvements to policy documents, including the development of a government-wide withdrawal policy. What ultimately transpired in Yuendamu on 9 November 2019 with Kumanjayi's killing was an extremely unlikely and tragic event. Prior to the shooting of Kumanjayi, Dr. Reeve was not aware of a single incident of a use of force by police in a remote community in Central Australia that had required an emergency response. Sergeant Frost gave evidence to the same effect. Rather than considering the increased police presence in Yuendamu created a greater need for a health or emergency response, Dr. Reeve considered the opposite to be the case. He viewed the police presence in the community as a protective factor. It's very difficult for this court not to judge the decision to temporarily withdraw the nursing staff through the prism of hindsight and knowing that Kumanjayi would require an immediate emergency response several hours later. However, of course, that was not and could not be known to Dr. Reeve. Your Honour, NT Health did engage with this inquest fully and frankly and in good faith as senior counsel assisting urged at its commencement. Relevantly, NT Health facilitated the gathering of a considerable body of evidence, in addition to that gathered by police in the Coronial investigation and the criminal investigation. 11 staff from NT Health gave evidence in person. Among the matters touched on in the evidence NT Health staff provided to this inquest, Your Honour, was the experiences of occupational violence by those staff. Healthcare workers in remote communities are at a significant risk of occupational violence. This is addressed at length in the affidavit of Ms Fleming, the Director of Work Health and Safety at Northern Territory Health, whose affidavit is at tab 9.4a in the brief of evidence, Your Honour. It is also reflected in the evidence of Dr. Boffa from Congress. The literature cited by Ms Fleming in her affidavit establishes that nurses generally experience workplace violence at a rate 4 times higher than the average employee, and the risk is higher still among remote area nurses. Dr. Boffa's evidence was that remote area nurses experience rates of violence 2 times higher than their urban counterparts. Analysis of incidents of severe violence towards remote area nurses demonstrates that the significant risk factors are being female in and around your accommodation and after hours. Violence against remote area health workers is often overlooked and underreported, as was observed in the context of silence report, which is referred to in Ms Fleming's affidavit. The Remote Safety Project instituted by NT Health following Miss Woodford's death in South Australia recognises it is vital that health services in the Territory can recruit and retain high-quality nursing staff to work in remote communities, and that in order to do so, nurses must be kept safe at work. The need for health services to ensure staff safety is again uncontroversial, and it's reflected in among other things, employers' legislative duty to ensure the safety of their staff at work, the policy and advocacy of peak bodies, including the Australian Nursery and Midwifery Federation and CRANA Plus, the adoption of zero tolerance policies by state and territory governments, and the withdrawal policies both of NT and ARCHO Health Services. Relevantly, Your Honour, the policies of both NT Health and Congress prohibit staff from seeing patients at staff accommodation under any circumstances. Congress's policy states dispensing of medication and providing other treatment from staff accommodation, no matter how minor, is not acceptable. This is not supported by management and will be considered inappropriate conduct. This reflects the assessment by that organisation that admitting patients into staff accommodation poses an unacceptable risk. This assessment applies many times over in my submission to the risk posed by attempted invasions to staff homes after hours. Your Honour, prior incidents of break-ins and home invasions in Yuendamu had resulted in considerable efforts to address that behaviour and to engage with the community to develop solutions. This is addressed in Part E of NT Health's written submissions. Broadly, these efforts encompassed the following. 1, discussing the offending at monthly Community Safety Action Plan meetings. 2, convening a Yuendamu Community Safety Committee framework. And 3, calling further community meetings specifically to discuss the increased offending. Community Safety Action Plan meetings were facilitated by NT Police around bringing together the community and were attended by various stakeholders, including Night Patrol, the Women's Safe House, the Yuendamu Old Persons Program, the Yuendamu School, WIDAC, Yuendamu Mediation, Territory Families, the Clinic, and a number of community elders. Miss Simmons and Miss Watts attended those meetings on behalf of NT Health, and children and break-ins was a standing agenda item at these meetings. In March 2019, in response to increasingly problematic crime in Yuendamu, Superintendent Nobbs determined police needed to do something decisive. He visited Yuendamu for a week and established the Yuendamu Community Safety Committee framework, consisting of fortnightly meetings, of which he continued to chair. During this first week, he held multiple meetings, including discrete conversations with different groups, elders and stakeholders. Superintendent Nobbs described the actions taken as follows: implementing high visibility patrolling as a circuit breaker, broad-based community engagement around target hardening strategies, building an integrated interagency framework and identifying repeat offenders and supporting them through an end-to-end model. Community meetings were also called by other stakeholders to address the increase in crime in 2019, and Ms Watts recalls attending at least 2 such community meetings in 2019, specifically called to try to resolve escalating crime. Unfortunately, despite the efforts of those involved, these were not successful. Your Honour, Part F of NT Health's written submissions address the withdrawal of the nursing staff from Yuendamu on 9 November, including the various discussions between staff within the community and in Alice Springs. In its written submissions, NT Health has sought, insofar as was possible, to adopt Council Assisting's summary of those events, and there was agreement on a number of factual matters. However, there are also a number of material points of departure, and these are set in detail in the written submissions and summarised at paragraph 137, Your Honour. For example, Council Assisting's account of the night of 8 November 2019 omits 2 of the attempted home invasions against the clinic staff. The relevant facts, Your Honour, leading up to the temporary withdrawal were as follows. On 6 November 2019, Miss Simons's home was broken into. The offenders attempted to gain entry by smashing a hole in the gyprock roof, and then using a shovel, they jimmied the security screen off the window. In addition to a shovel, other tools were scattered around the yard. Inside, Miss Simons's home was ransacked and everything was everywhere, according to her. Miss Simmons was understandably shaken up by the offending. One day later, on 7 November, Miss Simmons's car was broken into at the clinic. The passenger window was smashed and the car was rummaged through. The following day, on the evening of 8 November 2019, across the community there were 3 attempted home invasions at the homes of Miss Watts, Miss Meredith and Mr Alting, and an attempted break-in at Miss Simons's home, and the Rewalker's vehicle was broken into in their driveway. The clinic ambulance was also ransacked outside Miss Watts's house. In the attempted invasion of Miss Meredith's house, the intruders attempted to peel back her corrugated iron roof to gain access while she was inside. Intruders similarly climbed onto Mr Alting's roof. In the attempted break-in at the Simons home, a pickaxe was found wedged in the window and other tools, including shovels, were scattered around the yard. The force used in the attempted break-in was sufficient to shake the walls of Miss Watts's house next door and wake her. By way of comparison, Your Honour, the number of attempted unlawful entries at nursing accommodation on the night of 8 November was equal to that recorded across the entire southern region on 6 November. On 9 November, the clinic was closed as it was a Saturday. Shortly before 9 a.m, Miss Holland called Miss Watts to conduct the on-call handover. Miss Watts told about the events on First Street overnight. And thereafter, Your Honour, followed a number of telephone conversations and meetings between staff relevant to their safety. It's not practicable for me to address those comprehensively now, Your Honour. However, I do note that it was upon gathering at the Rewalker's house and learning that nurses' homes across the community had been targeted by the offending that the nurses decided to seek approval to be temporarily withdrawn from the community. During the course of those meetings that morning, it was also confirmed that none of the patients on the vulnerable person list in Uendamu were acutely unwell. Prior to the withdrawal, steps were taken to notify the community of the withdrawal, including it was announced to the assembled community via loudspeaker. That afternoon, additional medication was also dispensed and access to the morgue was arranged. At around 3:30 p.m, the last of the nursing staff departed the community. Your Honour, Part G of NT Health's written submissions analysed the decision to temporarily withdraw staff, and as I've stated, NT Health maintains that the decision to withdraw was a necessary and proportionate response to the escalating circumstances faced by those nursing staff. We submit, Your Honour, that you should find that there was a need to withdraw in the circumstances for the following reasons. The level of threat to staff was both subjectively and objectively serious. There were no other mechanisms immediately available which could ensure staff safety on the nights of 9 and 10 November. Methods previously tried had not prevented the escalation of crime. And even with the benefit of hindsight, the only identified solution that may have been implemented in the time available and adequately addressed staff safety was engaging security guards. However, this had not previously been attempted to preserve health services in a community. It has been since. Further, the risk to those living in community associated with the temporary withdrawal of staff and the reduction of services was objectively low, given the coverage to be provided from Ualamu and as the retrieval data provided to this inquest demonstrates. Your Honour, each of those points is addressed in detail in the written submissions. Notwithstanding that conclusion, it is acknowledged by NT Health that there were shortcomings with the decision-making process, as I've stated. A written risk assessment was not completed in relation to the withdrawal in the circumstances it could and should have been. Local Aboriginal staff were not adequately consulted in relation to the withdrawal of the other clinic staff. They needed to be. Those staff are valued members of the health service, and further, those staff may have had insights not available to the non-local staff. Though local staff were not included in the discussions regarding the potential withdrawal, the offer for those staff to be withdrawn to Alice Springs with their family was made. NT Health acknowledges also that in the circumstances of this withdrawal, more extensive discussions should have taken place with NT Police prior to it occurring. The deficiency in the previous policy requiring simply a notification of police I've touched on. Further, NT Health accepts that greater effort should have been made to discuss the potential withdrawal of staff with community leaders before the decision was made. In view of these shortcomings, which are accepted, Your Honour, amendments to policy documents have been made by NT Health. There are just a handful of other additional issues I wish to address. Firstly, Your Honour, both Naja and Counsel Assisting submit that the coroner should find that it was possible for Kumanjayi to have survived his injuries if he had received treatment at the Uendamu Clinic, and do so by reference to the report of Professor Michael Reid, prepared for Mr Rolfe's criminal trial. Frankly, Your Honour, this was a surprising submission to receive in closing, given Professor Reid was not required to give evidence during 68 days of these hearings, nor was his evidence prepared for this inquest or cited during this inquest or put to any other witness. In any event, we submit that properly considered, Professor Reid's evidence does not provide a basis for the findings that are proposed for the reasons that are set out in our written submissions, and particularly when the totality of his evidence at Mr Rolfe's criminal trial is considered. Second, Naja has made both primary and reply submissions in support of a finding of institutional racism. I wish to say something of the procedural history and previous rulings relevant to this, Your Honour. On the 9th of May 2022, Naja sought inclusion on the issues list of the question of whether there was any evidence of systemic racism or cultural bias in NT Health or some sections of it. On 26 May, NT Health filed written submissions in opposition to the inclusion of that question in the issues list. That same day, the question was rejected by Counsel Assisting as too broad, and it was omitted with Naja's consent from the revised issues list. On 26 July 2022, Naja commissioned a report addressing substantially the same question that Naja had agreed to omit from the issues list. On the 16th of September, that report was finalised. It was circulated to the parties 2 days later, and NT Health and others objected to it. After the parties' submissions were filed, Naja commissioned a supplementary report which purported to remedy some of the issues identified in the original. It did not do so, and NT Health and other parties maintained their objections to the original report and extended them to the supplementary report. On 27 April 2023, Your Honour, you ruled that you would not receive the original report or supplementary report, save for certain parts of Part 3 of the original report. The parts of the reports dealing with the supposed racism in NT Health were excluded in full. The result is that now Naja seeks for findings and recommendations to be made in relation to an issue which was excluded from the issues list with Naja's consent, is unsupported by expert evidence, and which was not the subject of particular inquiry during this inquest. That history to one side, the findings sought by Naja should not be made in our submission for a number of reasons, and these are set out in our written submissions also. They include the following. Firstly, Your Honour, and fundamentally, the Brigginshaw standard applies in relation to a finding of racism against an individual or an institution. We submit that Your Honour could not be satisfied on the available evidence that allegations of institutional racism could sustain a finding to that standard or at all. At paragraph 256 in their reply submissions, Naja refer to 3 authorities and purport to set out their combined effect. That summary provided is selective in our submission, Your Honour, and we note that in quoting Sharma at 172, Naja omit the remainder of the paragraph, which relevantly reads, "It was common ground at first instance that the standard of proof for breaches of the RDA is the higher standard referred to in Briginshaw and Briginshaw. Racial discrimination is a serious matter which is not to be lightly inferred." To the point made by Mr. Bowe yesterday, that agencies at this inquest appear offended at the notion that a finding of institutional racism could be made against them, I would say this, insofar as my client is concerned, it is a serious finding, firstly, and second, it cuts against the volume of work that NT Health is doing, which demonstrates its real commitment to First Nations people and to strengthening the way services are delivered. Some of that is in evidence before the court, Your Honour, for example, in the affidavit of Jennifer Hampton. However, much of it, including the work being done by the Chief First Nations Health Officer, for example, is not. The evidence that is cited by Naja in support of the supposed institutional racism is, in our submission, remarkably thin. For example, Naja submits that factors as broad as generally poor decision-making are both evidence for and constitutive of institutional racism. A further difficulty with this submission is that it was not put to many of the witnesses whose words and actions are now cited as indicative of racism. No opportunity was provided to them to respond as it properly should have been. This notably extends now to a proposed finding of racism against the RFDS, who is not a party to this inquest. In Naja's reply submissions at 233 to 239, they submit that pointing out serious harm to service providers in Yuendamu and other remote communities is a concerning race-based process of generalisation, because there is no link between the events apart from the fact of the persons involved being Aboriginal or Torres Strait Islander. That submission is rejected, Your Honour. There is nothing in the material we refer to which identifies the race of the perpetrator or perpetrators in these incidents, or indeed of the race of the victim or victims. The staff withdrawn from Yuendamu on 9 November 2019 were not all of the same race. Nor did all the examples cited in our submissions involve Aboriginal or Torres Strait Islander persons. The common factor linking these events, and the reason they are referred to, is that they are examples of occupational violence perpetrated against service providers in remote communities. It is occupational violence that service providers, both government and Aboriginal community controlled, including Congress, including Naja, have to and do take seriously. As to Congress's withdrawal from Mutijulu, Your Honour, we submitted in writing that this event is likely to be of very limited assistance to Your Honour in making your findings. In the event that you do wish to make findings in relation to it, as is pressed by Naja, we say that the contemporaneous email correspondence regarding the withdrawal, including who was consulted and when the service resumed, speaks for itself. There is common ground, Your Honour, I'm pleased to say, between NT Health and Naja on the desirability of transitioning to community-controlled health organisations. Where we depart is that transition should occur in all communities immediately. There is no evidence before Your Honour that that is desirable or achievable. Again, this is an issue that Naja sought to add to the issues list in May 2022, then consented to its omission and now presses for findings in relation to without evidence to support. Briefly, Your Honour, on the subject of cross-cultural training, Mr McMahon submitted yesterday that he was surprised there was not more enthusiasm for this. I'm pleased to tell Mr McMahon there is enthusiasm at NT Health. Your Honour may recall Ms Heinrich made available to the parties NT Health's Aboriginal Cultural Awareness Program, or ACAP. That's a program developed in combination with Flinders University and in collaboration with senior Aboriginal staff from NT Health. Ms Heinrich invited parties to comment on that program, Your Honour, during her evidence, and this invitation stands to Mr McMahon's clients or indeed to any others. Finally, Your Honour, I note, as Mr McCarthy did, Councillor Sisting's indication that recommendations are to be proposed on Tuesday next week. NT Health welcomes those recommendations and the recommendation that was flagged yesterday. NT Health has proposed 5 recommendations of its own at paragraph 604 of its written submissions, if they're of assistance. May it please the Court.
Thank you, Mr Hutton.
Your Honour, I note the time now and that we might have a morning tea break. Might I just address one matter that was raised earlier by Ms McNally? I'll take a bit more time later, but I just need to correct the record about one issue, and that is in relation to the suggestion that her client has not had an adequate opportunity to participate. I want to address particularly the suggestion that he could not provide more documents. Ms Wools, in response, has just gone and gathered some relevant email correspondence, and it won't be, Your Honour will not be informed about this by Ms McNally's written submission. In her written submission, at paragraph 6, she says, on the 9th of June 2023, we inquired of Councillor Sistings whether the coroner would issue Sgt Bowens a summons to produce documents or materials. What's not included in the written submissions of Ms McNally is the response from that. After that, as Your Honour will see if I mark these for identification, on the same date, Ms Wools replied to Ms McNally saying that her client was not under any obligation to produce any further material, but if he would like to produce some under a summons, she was inviting her to discuss that. They then had a phone call where there was an invitation to draft a schedule to a summons. That was never done. And then following that, some months later Ms Wools invited her to draft a schedule that could be issued if he would like to produce those materials under summons. That wasn't done by Ms McNally. Then on the 20th of September 2023, Ms Wools sent to Ms McNally an email which includes, it's clear that Sgt Bowens is in a unique position to provide helpful evidence to the court about a number of matters, including, for example, the resourcing and operation of the IRT. I also note your email below about the possibility of Sgt Bowens providing further documents to the court, noting that Sgt Bowens participated in 2 recorded statements and gave evidence at the Supreme Court trial of Mr Rolfe. We invite him to provide a written statement that addresses any additional matter that it would assist the coroner. That written statement can attach any further documentation that he believes would assist Her Honour in her task. It is hoped that in providing a statement, the process of Sgt Bowens giving evidence will be as efficient as possible. And further, if Sgt Bowens would like to do this and feels he would like assistance, in addition to your assistance, Superintendent Lee Morgan can make arrangements for that statement to be taken. So every opportunity was provided to Sgt Bowens through his legal representatives or through the officer in charge to assist this court in that regard. There was a follow-up letter after Sgt Bowens gave evidence. Mr Rolfe gave evidence nominating the TRG awards when it was discovered that in fact Sgt Bowens was a recipient of one of the racist TRG awards. A letter was written to him by Ms Wools on the 27th of March 2024, setting that evidence out and inviting Sgt Bowens to provide a supplementary statement addressing those matters, which he did. Thank you, Your Honour.
Thank you for that clarification in relation to further opportunities for Mr Bowens to put on additional evidence if he chose to do so.
And that, please.
Coroner, it's Ms McNally here. If I could just make short reply submissions.
Ms McNally, sure. Go ahead.
Thank you, Coroner. I thank Dr Dwyer for those comments, which in fact demonstrate the point I had made earlier. Firstly, it is not the role of witnesses to collate and provide documents to the court. That's Councillor Sisting's role. I've made the point that my client had extremely limited funding and did his best. And thirdly, when he was in court and attempted to provide further comment, he was not able to. So I acknowledge the points of Dr. Dwyer and say that they are exactly the points that I was making this morning.
Thank you for that additional assistance. We'll now break
Thank you.
for the short morning tea adjournment.
All stand. The Coroner's Court of the Northern Territory is now adjourned.
It's completely ignored. Of course, yeah.
Silence will stand. The Coroner's Court of the Northern Territory is now in session.
Mr. McMahon.
Before Dr. Freckleton starts, I just advise, Your Honour, that Robin Japananka Granitz is in court, who was discussed yesterday.
Thank you. Good to see you, Mr. Granitz. Dr. Freckleton.
Thank you, Your Honour. To commence, Ms Bernard and I acknowledge the custodianship of the unceded lands of the Arunta people where this inquest is taking place, and we pay our respects for the hospitality and the tolerance of the elders of this land, those from the past and those who are present today, including Mr Granitz from the Warlpiri. We would like to make particular mention of the generosity of spirit of the many members of the Warlpiri who have interacted with us in a collaborative way, looking to forge a new and constructive relationship with the Northern Territory Police Force. In that context, we acknowledge too that the legal representatives for the families, Naja, and for Paramparoo have interacted with those representing the Northern Territory Police Force in a collaborative and constructive way throughout. We hope that this will provide a basis and a model for ongoing cooperation. We start our submissions by reiterating our condolences to the family and friends of Kumanjayi. There were many who valued him and loved him, and it's very important that that be acknowledged in proper memory of Kumanjayi. We have identified a series of apologies made on behalf of the Northern Territory Police Force in our written submissions, but specifically now we apologise for the role played by members of the Northern Territory Police Force in Kumanjayi's death and for the events after his passing, in particular the unauthorised conduct of Mr Rolfe, but also the carrying of long arms before and after his death, decoy plan involving the ambulance, and the way in which Kumanjayi's passing was communicated to his family. Northern Territory Police Force commenced its involvement in this inquest by promising to listen and committing to learn. We meant it, and we have learned a great deal. Ms Bernard and I have, but so have senior and less senior members of the police force who have been present throughout this inquest. How seriously the force has taken this inquest is demonstrated by the presence of a Deputy Commissioner throughout the whole process. We are here not to provide platitudes, but what we have done already within the Northern Territory Police Force is to make real changes to reduce the potential for an avoidable death like Kumanjayi's to happen again. Northern Territory Police Force said that it would cooperate fully with the inquest, would not advance technical arguments, and would refrain from combative cross-examination. We said that if counsel assisting needed documentation or assistance, it would be provided. We have endeavoured to keep to that approach throughout this lengthy process. In our submissions, we have provided extensive analyses of the evidence in an attempt to provide information and a practical policing perspective. The Northern Territory Police Force has made multiple concessions, as outlined major reforms that it has set in motion. To use the words of counsel assisting yesterday, in these oral submissions, we too will not engage in sugarcoating. Some of what we say will be confronting to certain of the parties, but what we say is considered, and we hope that it will be received in the spirit in which it is given. We have endeavoured in these submissions which we're going to put before you today to incorporate two particular considerations in our presentation. First, what we say to Your Honour is that there is a need for intellectual rigour and restraint in the making of both findings and recommendations. Entirely understandably, there are broad-based objectives which a number of the parties to this inquest have. An example we've just heard about is the campaign waged by Sgt Bowens and Ms McNally to bring back the IRT or some variant of it. That is not going to happen. It does not follow that because a death prompts reflection on social, legal, criminological, sociological issues, policing issues generally, it is appropriate that they be the subject of coronial comments or recommendations. Such comments and recommendations have a particular status, and they have a specific statutory authorisation, and they're subject to preconditions. I'll say more about that soon. Secondly, we make the observation that policing in the contemporary Northern Territory has particular challenges and stresses. As counsel assisting has accurately observed in terms of Newton's, policing in the Northern Territory is a stressful and demanding job. That is an understatement, because the challenges of such high levels of domestic violence, as Your Honour set out at the start of this week, burnout and cross-cultural complexity, along with short staffing, make the process of providing sensitive, trauma-informed and culturally aware policing very challenging indeed. These forms of policing are a marvellous opportunity for new and mature police to work with persons of remarkably diverse First Nations backgrounds, as well as ours. And those opportunities enrich the experience of being a police officer. But along with the richness comes chronic exposure to trauma, anger, and distress. Now, this is not a request for sympathy, merely an observation of the context of provision of policing services and the reality of the policing environment. We commence submissions by some observations in relation to submissions advanced by those representing Mr. Rolfe, as he now is. I'll refer to him as Mr. Rolfe because he has been dismissed from the Northern Territory Police Force, so he is no longer a serving member. He should not be referred to any longer as constable. we would like to delineate what we submit is the proper line for engagement in this inquest by way of findings. And in this regard, we depart significantly from Mr. Rolfe and Sgt Bowens, and we have a slightly different perspective to that of the families Naja and Paramparu. From the perspective of the Northern Territory Police Force, the line needs to be drawn when the first shot was discharged by Mr. Rolfe. From then onwards, in our respectful submission, what occurred was the province of decision-making by a jury in the Supreme Court of the Northern Territory. So we offer no submissions as to what took place after that, the propriety of it, the prompts for it, or the legitimacy of the discharge of the firearm. In our respectful submission, that ought not to be traversed by this inquest because it is the territory of the criminal justice process. But, and this is where we depart markedly from those representing Mr. Rolfe and also Sgt Bowens, what occurred right up to that point, we say is the province of this inquest, subject to some limitations, as I shall articulate. Most particularly, what took place in the decision-making leading up to the entry into houses 577 and 511, and even what took place within 511. That isn't to reflect on the propriety or legitimacy of the discharge of Constable Rolfe's firearm. It is to enable a proper understanding of how the tragic events took place, what the influences may have been, what the motivations might have been. That is at the very core of Your Honour's obligation under the Act, make findings about the circumstances of Kumanjayi's death. We listened attentively to what was said by Mr. Officer yesterday, and one thing particularly struck us. He was keen to put submissions to you about cause of death and to draw inferences about what should not be within your province, what should be outside the scope of the inquest. But he mentioned very little about circumstances of death. We don't know if that was deliberate or inadvertent, but the distinction between the two matters is fundamental to the operation of this jurisdiction. Circumstances of death enable Your Honour to investigate and make findings about the context of a person's death, how it occurred, the manner, all of the things surrounding a death, leading up to, and to some modest degree, what occurred in the aftermath as well. That is the very essence of contemporary coronership, where we have narrative findings which enable persons, for instance, within the Yuendamu community, to understand better how it could possibly be that police officers entered a house and how the events after that ensued. To suggest that there should be a preclusion on looking at those matters in our submission fundamentally misconceives the nature of a coronial responsibility. Now, many submissions have been made on behalf of Mr. Rolfe in particular in respect of the scope of this inquest. Your Honour has made two key rulings, and I won't identify the essence of those in any detail, save to summarise them as we apprehend Your Honour ruled. In your second ruling, you dealt with objections made to the scope of the investigative process of the inquest, rejecting arguments advanced on behalf of Mr. Rolfe about receipt of evidence about text messages and the evidence of Ms. Campanero. And the essence of Your Honour's ruling was that you were prepared to investigate whether the text messages constituted evidence that Mr. Rolfe was racist or that there was a culture of racism in the IRT or his patrol group, and if such racism played a conscious or unconscious role in the acts which caused death. You found that this was potentially relevant to the circumstances of death. Now, there have been times in Inquest when we have been quiet and other times we've been assertive. We were quiet about that because it appeared to us that it was appropriate for Your Honour to investigate those matters, and it was in the public interest that you do so. In your third ruling, you dealt with a further set of objections that were advanced by Mr. Rolfe. And some of this was usefully summarised by our learned friends this morning. There was a sequence of interactions about the parameters of the inquest with a provision of a scope document by counsel assisting early, and acceptance of it by Mr. Rolfe, and then a reneging on that and various other controversies. And by the time of ruling number 3, you dealt with multiple objections from Mr. Rolfe to the receipt of various categories of evidence. You concluded that the evidence about the honesty of Mr. Rolfe's application to join the police force might prove relevant to his credibility and reliability. You found it wasn't possible to determine whether the force recruitment policies were connected with the death, but they could have adversely affected the decision to offer him employment. You said it wasn't possible to decide at that stage whether more robust recruitment processes would have disclosed attitudes or pathology suggesting Mr. Rolfe was not suitable to be employed. You ruled too that expressions of contempt from Mr. Rolfe about females and bush police had the potential to be highly relevant to whether there was a deliberate disobedience to the plan of Sergeant Frost, and that the text messages suggested a prima facie association between those sentiments and inappropriate attitudes toward the use of force. We considered that Sgt Bowens and Sgt Kirkby's text messages, and I'll return to these, should Ms McNally be listening, were prima facie evidence that those members held and tolerated racist or inappropriate attitudes and expressed those to their subordinates. You observed that the ill discipline demonstrated by the messages might be relevant to why the action plan was not carried out, the development of attitudes and behaviours of Constable Rolfe, or whether Sergeant Kirkby tolerated or encouraged dishonesty by Constable Rolfe. We did not urge Your Honour against those rulings. We identify no rule error in them. They had occurred at an early stage in the inquest process and identified what evidence you were prepared to listen to. But of course, what you listen to and what you draw upon ultimately in your findings are two different things. Your rulings enabled the reception of a variety of forms of information, including what Ms Campagnaro had to say, what was in the text messages, and you indicated preparedness to hear about various uses of force engaged in by Mr Rolfe prior to what occurred in relation to Kumanjayi. We agree with Mr Officer to this limited extent. We've reached the point in the inquest now where it is your role to make findings about circumstances of death in particular. Now that's where the legislation guides and delineates what Your Honour can do. It is correct that insofar as Your Honour might contemplate making Section 34(3) comments on public health or safety or the administration of justice, they must be, these are the words of the legislation, connected with the death. Under Section 35(2), you're empowered to make recommendations on, and I quote, a matter including public health or safety or the administration of justice connected with the death. So, same words, connected with the death. Likewise, Your Honour is obliged under Section 26(1) to investigate and report on the care, supervision and treatment of the person while being held in custody or caused or contributed to by injuries sustained while being held in custody, and you may report, that's how it's put in the legislation, on a matter connected with public health or safety or the administration of justice that is relevant to the death. In an inquest such as this, under section 26(2), you must make such recommendations, it's obligatory then, with respect to the prevention of future deaths in similar circumstances as you consider to be relevant. Now, the bottom line of reviewing carefully the work that's in the legislation is that your powers are enlivened in respect of findings and comments and recommendations when what you are contemplating is connected with the death or relevant to the death. And it is more than apparent, and it's appropriate to take a purposive approach to interpreting section 26, that you are obliged under the legislation to make such recommendations with respect to the prevention of deaths that bear any similarities to Kumanjayi's. What this means is that Your Honour has considerable latitude in relation to making comments or recommendations or reporting, but there does have to be a nexus of the required kind. They can't be tangential, they can't be peripheral to your findings, and your findings have to be about, for these purposes, cause and circumstances of death. That has ramifications for a number of the matters that have been raised before you and which are traversed in the, 1990 pages of submissions that you now have. In our respectful submission, it means that there are some limitations, not the kinds of limitations proposed by Mr. Rolfe or Sgt Bowens, but there are some limitations upon the kinds of comments and recommendations which it is open for you to make. I propose now to develop that proposition further. Now, you've heard a reiteration of the aggrievement of two of the persons involved in the obnoxious text messages that they've been used in these proceedings. What you do know is that Justice Bowens found that they had been lawfully obtained, and the position of the Northern Territory Police Force is that you can draw upon the unedifying contents of those text messages as you deem appropriate, provided that you identify matters within them which show propensities or tendencies or a state of mind or an attitude which is relevant for your findings about cause or circumstances of death. Now, there are some very straightforward things that can be said about these text messages. You've heard plenty about them prior to now, but it's absolutely undeniable that Mr. Rolfe is a racist. People who talk about loser locals, coons, Neanderthals, losers on the basis of their Aboriginality are racists. And it's important to call it as it is. And the position of the Northern Territory Police Force is that it is trying to call it as it is and do something about people who behave that way in its force. And the commitment from Mr. Murphy is to be robust in that regard. And we have no reservation in saying to Your Honour that you too should make robust characterisations of communications of the kind in which Mr. Rolfe engaged. So he's a racist. It's also clear enough that he is sexist. He's a misogynist. He's homophobic. He has disrespect for authority, and he has contempt for bush cops. The language in his texts is eloquent as to his values and his attitudes. And some of those who corresponded with him and communicated in a similar kind are the same. those are values which are just inconsistent with contemporary policing anywhere in Australia, and that includes the Northern Territory. And the evidence from these texts has been corroborated by aspects of Mr. Rolfe's own evidence in this court, and his demeanour and his evasiveness and witness box. He lacks insight, he has a propensity to deny what cannot be denied, and he rationalises what he cannot avoid confronting. All told, a combination of his evidence and the texts, together with collateral evidence, establish in our submission that Mr. Rolfe's credibility is, to put it in a very generous way, open to serious doubt. He's prepared more robustly to deceive, to lie, and to misrepresent when it suits him. And we know that from a key exchange which he had with another witness about his camera and what he would shift in order to enable proper vision of what was actually taking place. And that was Sergeant Cooper. So it's reasonable to conclude that disingenuous approaches have suited him in this court. So what then do these propensities or characterisations of the disgraced Mr. Rolfe mean for the findings that should be made by you? Now, it was suggested yesterday that the Northern Territory Police Force and others, I think, were uncomfortable with the R word. We're not. We're not uncomfortable with naming the word or naming the people. And that's why we have straightforwardly characterised the sort of person that the former Constable Rolfe is. So what about those propensities? Where are they relevant to Your Honour? We answered that by reference to what you framed as potential relevance in rulings number 2 and 3. It seems to us that the particular relevance is in relation to how he, de facto leading the 5 persons at Uendamu on 5 November 2019 did when they left the room where the briefing from Sergeant Frost took place. Did I say 9 November? I suddenly said 9 November. I meant 9 November. The evidence of what occurred in that briefing is not entirely clear, but quite an amount is now. Sergeant Frost remitted a plan to the IRT members and Mr. Donaldson by email, and then she conducted a briefing with them at the station. We joined counsel assisting in her analysis that the briefing in essence had 3 phases. There was a very limited one with Mr. Donaldson, after which he took himself off to familiarise himself with Uendamu, with Loki the dog. Then there was a more extensive briefing, and the key briefing, that involved Constable Kirstenfeld and Mr. Rolfe. And finally, there was some interaction when the 4 men were present and Mr. Donaldson returned and Constable Alafeo was also within earshot. Now, it seems to us that it's useful to review the content and purpose of Sergeant Frost's plan, and we excerpt that at paragraph 712 of our submissions. But it contemplated 2 aspects to the task given to the IRT, and that was a task that had been authorised by Superintendent Nobbs, and it had been passed by Assistant Commissioner Wurst as well. But essentially it was Sergeant Frost's plan. And we stand behind that plan. It was a good plan. One can say it might have had some more. Ideally, it might have had a risk assessment. But it wasn't a TRG plan. It was a straightforward indication of what was required of the IRT members with assistance from Mr. Donaldson. And so what was required? Well, first of all, there were to be high visibility patrols and response to call-outs. And the idea of it was that started at 11 o'clock. Why then? Because they were there as supplementation to exhausted local resources. And that was going to enable local members to get some rest and commence again with their responsibilities the next day. That's important. That was one of the major reasons why they were brought into Uendamu. It wasn't all about arresting Kumanjayi. Now, it was definitely the objective of taking Kumanjayi into custody. The aspiration was to do that when the funeral was concluded, and that had been the subject of discussions with members of the family in the days before, Wednesday, Thursday, Friday. The hope was still there that he might bring himself into custody or be escorted by family members prior to the next morning. But absolutely at the core of the plan was that it be done a little while after 5 o'clock. Why 5 o'clock? Well, Mr. Alafeo was required to attend the police station at 5 and participate in the real nuts and bolts briefing as to how the apprehension was going to take place. It was going to be where? It was going to take position in one place or another. Where was the best place to go first? Because there were a number of houses that were identified as potential places where Kumanjayi might be. So that next opportunity for planning was crucial. And secondly, Mr. Alafeo was going to be there. Now, in the best of all worlds, it would have been Akbar Williams who was there, but there were some issues in relation to him and exactly when he would have completed what he had to do in relation to matters associated with the funeral. Also, he was related to Kumanjayi. That didn't completely preclude his involvement, but he had leave and there were a number of issues as to whether he was the person. The key thing was that someone be present who could, one, recognise him, which of course ended up being important, and two, be a source of familiarity when Kumanjayi was being taken into custody. So it did not be just persons, strangers, to use the words that have been employed here, from out of town. An integral component to the plan. And there was something else. And something very contrasting to the way in which Constable or Mr. Rolfe tended to go about his policing practice. It explicitly contemplated that it would not be possible to take him into custody that next morning because there was no certainty as to where he'd be. There were pretty good ideas because it was known where he tended to sleep and which houses he tended to spend time in. That was fine art. The proposition that there was no idea is just spurious and advanced to distraction. But it's true that there was no certainty as to where he'd be. But then again, there isn't certainty about very many things in life. Yeah. Who knows exactly what any of us will be doing tomorrow morning? Tomorrow has possibilities. Some of them are good and some of them not so good. So it was expressly identified that if he could not be taken into custody, the same process would take place the next day. So Sunday morning, if that didn't work out, then Monday. Didn't have to be done overnight. There was no urgency. Kumanjayi needed to be taken into custody. There was a warrant out for his arrest. He'd engaged in a serious assault on a Wednesday, and there was a warrant to take him into custody as a result of his removal of his ankle bracelet and his decamping from where he was supposed to be. But it did not have to be done that night or the next morning. And Sergeant Frost's plan sensibly contemplated a patient and iterative process to bring him into custody. And we'll say something about the presence of Loki the dog later on. But part of the presence of a dog was to make arrangements for way of dealing with the situation should there be anything like what had taken place in the days before. So the plan of Sergeant Frost was a stark contrast to the primitive de facto plan, which ultimately was deployed by Constable Rolfe. Now, Rolfe's plan wasn't written down, and all we can do now is try to reconstruct what he had in his head and what went by osmosis to his colleagues. But what we can say of the Sergeant Frost plan was that it patiently and explicitly contemplated multiple attempts as necessary to take Kumanjayi into custody with the assistance of local input. At first, Mr. Alafeo, but potentially Akpo Williams later on. It depended how things evolved. The idea of that was to avoid the scenario that had unfolded on the Wednesday. What happened then, and we don't need to go into details of it for now, was that Kumanjayi was cornered in a confined space. He was worried about the well-being of his girlfriend. He was alert late in the afternoon, and he threatened officers with a weapon in what was a frightening episode. The Frost plan enabled further engagement and obtaining of advice from senior officers if Kumanjayi couldn't be located at first. It minimised confrontation, it maximised the potential for minimal use of force, and it drew upon the presence of local police to assist in the process. Now, at trial, Constable Kirstenfeld suggested that that the IRT members arrest Kumanjayi at 5 o'clock the next morning. Constable Kirstenfeld recalled that he contacted Senior Constable First Class Donaldson, asked him to come back to the police station and advised the plan on gathering information and intelligence as to the whereabouts of Kumanjayi that evening prior to the arrest the next morning. At Inquest, Constable Kirstenfeld accepted that he'd been told about the early morning arrest plan. So there we have it. Now, Kirstenfeld was with Rolfe. So what we can reasonably infer, what Kirstenfeld heard, Rolfe heard. Now, there were clearly questions posed, and the exact atmosphere of what took place in the interaction involving Kirstenfeld and Rolfe is not wholly clear, although there seems to have been some tension and some attitudinal issues. Constable Rolfe has said that Sergeant Frost mentioned she preferred that the IRT arrest Kumanjayi at about 5 o'clock because she wanted to have some time off. But if they did arrest him during the night, they were to call her and she and the other local police would attend and handle his custody and processing. So what you know from that is that Constable Rolfe plainly knew about the time, although he's rejected it as an arrest plan and referred to it as a timing issue. So that's what those two have had to say. There's also Constable First Class Alafeo. Now, he overheard some of the briefing while he was completing paperwork on the computer. You talk about paperwork on a computer? Probably not. Work on the computer. Constable First Class Alafeo heard that the plan was to arrest Kumanjayi at 5:30. So there we have three sources of information. It's straightforward that there was a 5:30 arrest plan after the 5 o'clock discussion amongst the relevant members. Now, Mr. Rolfe would have you believe that Sergeant Frost acquiesced in what essentially was a wholesale abandonment of the plan, and that she authorised them to go and pursue intelligence and be prepared to arrest Kumanjayi on the spot wherever they thought he might be. That is just an utterly implausible assertion, and it is not to Mr. Rolfe's credit that he persists in promoting this proposition. Why, we ask rhetorically, because of any interaction that took place at the station, would Sergeant Frost just jettison her wish that there be public order policing and dealing with call-outs? Why would she abandon that the arrest take place at 5:30 in the morning? Rolfe says, well, we didn't know where he was going to be. And anyway, arresting someone at 5:30 isn't all that helpful anyway. It's an awful lot better than repeating Wednesday or doing what was done on the 9th. Nothing's perfect. Why would she abandon having the involvement of Mr. Alafeo? Why would she agree that it be done in such indecent haste, completely contrary to the essence of the plan? Why would she suddenly acquiesce in some strange form of intelligence gathering? It appears that she probably authorised them to pick him up if they saw him, because that's probably going to be safe enough if they see him walking on one of the streets. But that's entirely different to barging into houses and repeating the Wednesday. And why would Sergeant Frost authorise an abandonment of a plan that had been authorised by Superintendent Nobbs? It just makes no sense. It's not true. It's a deliberate attempt to mislead you. Now, we know what happened. We know it from the very words that were used by Mr. Rolfe. We're here to grab Kumanjayi up. That's not intelligence gathering. That's a ham-fisted mission to arrest. Immediately. They walked out at 7:05, 7:06, and they were there within minutes. Just a complete obverse of what was in the plan. So, why did Rolfe so flagrantly disobey what he'd been told to do? That's where the text messages that you have allowed in, Your Honour, before this inquest is inside. You see, Sergeant Frost had three major deficits for Mr. Rolfe. First, she was a woman. And it's clear from the texts. We don't need to take you to the pictures and the pathetic sexist characterisations of Mr. Rolfe. He's a misogynist. Next problem for Sergeant Frost, she was senior to him. And by and large, Mr. Rolfe had no respect for authority unless it was somebody who shared his own worldview and was passive and acquiesced in whatever Mr. Rolfe wanted. Next, the third of the real deficits of Sergeant Frost from the perspective of Mr. Rolfe, she was a bush copper. Now, we know what he thought about bush coppers. They're lazy and they're contemptible. They are the antithesis of what Mr. Rolfe admires. They take their time. They establish relationships within a community. They don't rush into confrontations to do, as he put it, cowboy shit. They don't regard policing as operating in the Wild West. They take their time and they operate in the community in which they live. That's what Sergeant Frost did. That's what Sergeant Jolly did. That's what Senior Sergeant Schumacher does. It's what many of the really impressive officers who have appeared before you do. And it's the way in which they live their policing. So there are ample insights provided by the text messages as to why Mr. Rolfe might have been disinclined to obey Sergeant Frost and to take upon himself the construction of an alternative plan. Because one of the other aspects of Mr. Rolfe we can see readily enough is that he's a narcissist with grandiose ideas about his own abilities and his own knowledge and his own proficiency. He knows better than others. He wanted to get the job done, get his man, get out of the bush, come back to what he regarded as the comparative civilisation of Alice Springs and the comforts here. Then he'd be able to big note himself like he did on those various messages that he sent to people, preferably with videos. But he could do better than those characters, Hand and Smith, who he thought had made such a hash of what had taken place on the Wednesday. The people he'd derided as having capitulated in face of the behaviour of Kumanjayi. What we know about Mr. Rolfe's policing style is that it's impulsive, ill-considered, over-hasty, and unjustifiably aggressive. When we look back now with the wisdom that hindsight enables, we can see some of those characteristics and insubordination from the earliest days. What is Mr. Rolfe most proud of, and what is he angriest about before issues to do with Kumanjayi? When he dived into the river to save somebody, as it turned out, it worked out all right, fortuitously for him and for others. But he'd been told not to do it for good reason. It was dangerous. It was putting people's lives at risk. It could have gone hideously wrong. But Mr. Rolfe knew better. He wanted to be a hero. That's a consistent theme in Mr. Rolfe's life. So, in his mind, it was legitimate to ignore what he was told by senior officers and to do what he thought was best. Here we have it again with Sergeant Frost. What we know about Mr. Rolfe then, and this is consistent with the various other episodes in which he took people into custody, is that he is impulsive and ill-considered and regularly insubordinate. Again and again, he didn't bother to wear his body-worn cameras. Didn't want to, didn't need to, had a rationalisation for it, just didn't do it. It's only when finally Superintendent Reid brought him to task and said, this has got to stop, that reluctantly, presumably, he started to cooperate and do what was required of him. That's the only reason we've got body-worn footage for what occurred in November. So there are aspects to his personality which shed considerable light on what occurred in the late afternoon, early evening of the 9th of November. Impulsive, arrogant, overly assertive, grandiose, narcissistic. The text messages shed considerable light on the mindset which would have led to his feeling able to disregard what a female, experienced person in authority who worked in the bush had told him to do. First, it vindicates your decision to receive the evidence, and two, it legitimises your relying upon it when you make your findings in our submission. Now, I haven't used the R word in this regard yet. I will now. It is absolutely reasonable for Your Honour to reflect upon whether the other component in what took place on the 9th of November was racism. We know that Rolf was racist. We know that racist people usually translate their words into actions. That's just everyday experience. So, was racism a factor in what happened on the 9th of November? In our submission, there is no clear evidence of this. And it ends up being wholly speculative as to whether it was. He'd been engaged in many arrests before. I'll say more about that in a little while. He didn't say anything which indicated a particular racist attitude to Kumanjayi as an Aboriginal man. He didn't engage in particular behaviours which were unequivocally illustrative of his attitude toward First Nations people at Yuendamu. What he did was to be a really poor policeman. He didn't plan, he didn't listen, he didn't think, he just burst into action as a hero in his own head. In our respectful submission, there is ample reason to conclude that his sexism, his antipathy toward authority and his contempt for bush police played a role in why he did not comply with what was required of him by Sergeant Frost. In respect of racism, it becomes speculative. And just because he was a racist, it doesn't necessarily mean that racism played a role in his conduct. What we are urging upon Your Honour in this regard and in relation to the associated issue of institutional or systemic racism is what we've come to expect from Your Honour, the application of intellectual rigour to the issues, and these are hard issues and they're confronting ones. We hope that Your Honour may find the reasoning in the Tanya Day case from Acting State Coroner English of some assistance for you. And we've got copies of that, and we'll hand one up to you and distribute some to parties. We're confident everyone knows the case. I'm not going to take Your Honour to specific passages in any detail. I'll identify the sequence of things to you so that Your Honour can reflect on them in due course and see if you derive assistance from them. We say with respect to Acting State Coroner English, who's now a judge in the County Court in Victoria, that this is a particularly sophisticated and thoughtful analysis of the evidence before her. It was urged upon her that she make findings of institutional racism. And like you, in a preliminary ruling, we've provided you a copy of that, she agreed to receive evidence that might go to the existence of such racism. In her 25 June 2019 ruling, she accepted the urging of the family to hear such evidence, but at paragraph 72, she rejected, and I quote, the inductive reasoning that concludes through analogy that because Aboriginal people are overrepresented in public order offences as a result of systemic racism, Miss Day was necessarily charged with a public drunkenness offence because of systemic racism. She said this, it is similar to say Miss Day's poor outcome in custody is consistent with the statistics that show the disproportionate effect of the law against public drunkenness. Therefore, her outcome was caused by systemic racism. It might be consistent with it, but it doesn't make it causal. I won't labour this for the moment, Your Honour, but you can see that what your sister coroner in Victoria was saying was that you've got to be very careful in how you utilise information, the assumptions you make and the inferences that you draw. We urge Your Honour to reflect on paragraph 72 of Her Honour's ruling. She returned to it in her substantive findings on 9 April 2020, and at paragraph 110 she repeated comparable sentiments. Ultimately, she said this at paragraphs 111 to 12, I can only make my findings based on the evidence before the court if I'm satisfied to the relevant standard on the balance of probabilities. Further, any non-compliance with organisational policies or procedures does not necessarily make the causal act or decision the result of unconscious bias and thus illustrative of systemic racism. So she's very conscious of reasoning from the specific to the general. Ultimately, what Her Honour did was to make one finding at paragraph 225 that it was open to her to draw the inference that a particular man's decision-making process was influenced by an unconscious bias and immediately deciding Miss Day was unruly, putting her in a higher category of response without considering other options. She found the decision to define her as unruly and to call for police rather than pursue other options had been influenced by her Aboriginality. Now, what Your Honour can see in Acting State Coroner English's analysis is a very careful, restrained, intellectually rigorous analysis of the evidence and an engagement with whether, from the evidence, it was proper for her to find racism on the part of a key player or racism more broadly in the sense of institutional or systemic racism. She compromised. She found one key player to have been subject to unconscious bias, and she did not go further and impute that to any organisation. What we submit to Your Honour is that there are risks in inductive reasoning and drawing inferences over readily from one man's insubordinate and grossly imprudent behaviour, to be generous, and attributing that to an overall organisation. Now, what you know as a result of the unedifying information to which you are now privy is that Rolf, through his text messages and some of his friends and colleagues, are racists. You know various things about TRG practices, in particular up to around that 2015-16 mark. But you also have been privy to some fine and impressive and non-racist people. And no one has been able to point to a particular general order or policy which is said to be indicative of systemic racism. Now, these issues were canvassed in the rheumatic heart disease cluster of inquests in Queensland, with which Your Honour will be familiar, with the findings delivered by Coroner Nerida Wallace last year, I think it was. Very, very careful analysis of the failure to provide sufficient health resources in northern Queensland to identify and respond to basic staphylococcus infections and thereby be able to take measures to avoid rheumatic heart disease and rheumatic heart fever, and then the disease caused by damage from that disease. No finding of institutional racism there in a case where that was a genuine possibility. In the DHU inquest, presided over by your equivalent in Western Australia, State Coroner Foliani, findings were delivered on the 15th of December of 2006. Again, Her Honour very carefully reviewed the provision of care to the deceased woman. Evidence was received about cultural awareness training completed by police. It was found there were deficiencies in training of police. Recommendations were made about cultural competency. Ms Dew's family submitted that the approach taken to her by some of the doctors, and in turn the treatment that she received, was illustrative of institutional racism as described by an expert witness. Her Honour, again, in very specific and careful findings, did not find any of the relevant staff or police were motivated by conscious deliberations of racism in connection with their provision of treatment, but commented it would be naive to deny the existence of societal patterns that lead to assumptions being formed in relation to Aboriginal persons. It's a community-wide issue, and until there's a seismic shift in the understanding that is extended toward the plight of Aboriginal persons, the risk of unfounded assumptions being made without conscious deliberation continues, with the attendant risk of errors. This is where she went to in the end, paragraph 861. Very tragically, the social determinants of ill health of Aboriginal persons were borne out in Miss Dew's life and in the sequence of events that led to her untimely death. Now, you've heard this morning from our learned friend for the Health Department about the gravity of the making of findings about racism as a causative factor in relation to death or as being one of the circumstances of death. We echo the helpful submissions from a learned friend. To reiterate, because Mr. Rolfe was racist, doesn't mean his racism played a role in his discharge of his firearm. Doesn't necessarily mean that it played a role in his decision to go out searching for his man. And it's not properly to be attributed to the broader system or institution. We respectfully submit that the court should be circumspect, as the court has been in Queensland and Victoria and Western Australia, in too readily embracing the emotive terminology of systemic racism. It's a phenomenon. It is a reality. There are occasions where it would be entirely appropriate for you to utilise such terminology. Our respectful submission is that this is not one of those, and that a proper appreciation of what led to the delinquent conduct of Mr. Rolfe is to be found in other aspects of his personality, his policing style, and his attitudes. What we respectfully say is that it is not open to you on the evidence to find that racism figures amongst such considerations, or that it is appropriate or open to make a finding of institutional racism. We observe to you as well, in a way comparable to what was raised by Mr. Hutton, that it is important not to characterise with a highly pejorative and denigratory term an institution which is like the department that Mr. Hutton represents, and like the Northern Territory Police Force, making bona fide attempts to do better. We'll say more to you about the initiatives of Ms. Little in due course, but it has particular resonance for the Northern Territory Police Force because they are doing what they can to move in the direction of a 30% representation of Indigenous people. There's been terrible publicity, perhaps deservedly, of issues recently arising from the TRG gatherings and similar, and the text messages. That has caused discomfort, to put it very mildly, amongst the Indigenous employees of Northern Territory Police Force. And the earnest wish of the Commissioner is to attract more, not fewer, Aboriginal people to be ALOs, ACPOs and constables, and to retain them and to maintain some morale. To have Your Honour cloak what occurred associated with Kumanjayi's death in the term institutional racism would be very unhelpful. So what then of Kumanjayi's, what then of Mr. Rolfe's history of violence? Would it be convenient to stop for a while now, Your Honour?
Yes, we'll take the lunch break, but I don't think there are time constraints this afternoon.
Your Honour, could I respectfully seek leave to be excused
Thank you.
After the lunch break.
Yes, thanks for being here.
Goodbye.
We'll adjourn.
Court stands. The Coroner's Court of the Northern Territory is now adjourned.
Someone holding up a time in your hour.
But we've got time constraints.
Right?
We've got time constraints.